The beautiful city of Arusha, which is the third important city in the Republic of Tanzania, is the seat of the African Court on Human and People's Rights. The court, that celebrated its 10th anniversary in November 2016, is presently in this temporal site offered by the Tanzanian government along the Dodoma Road. The establishment of an African Court on Human and People's Rights in 1998 by the Protocol to the African Charter of the African Union and the subsequent operationalization of the Court in 2006 to complement the protective mandate of the African Commission on Human and People's Rights was a bold step taken by African leaders to set up a judicial rather than a quasi-judicial body to ensure the enjoyment and protection of human rights on the African continent.
If you're looking for relaxation and a place to rest a while, don't take too long, follow the song, conga line in single file. Play the music.
This court has been giving advisory opinions and entertaining matters on human rights abuses on cases addressed to it by litigants from states that have ratified the protocol and have deposited their declaration. This is the courtroom in Arusha, Tanzania, where matters pertaining to human rights are being addressed by judges of the African Court on Human and People's Rights. Behind me, you find where the judges sit when they want to preside over matters. On my left hand and on my right hand are the docks where the plaintiffs and the defendant usually go in to plead their matters. After 10 years of existence, that is, from 1996 to 2016, the court's administration, following the declaration of 2016 by the African Union as the African Year of Human Rights, decided to celebrate 10 years of human rights protection in Africa. The venue for the celebration of the 10th anniversary of the African Court was this magnificent Mount Meru Hotel that adopted its name from Mount Meru in Arusha. After 10 years of existence, officials of the African Court on Human and People's Rights decided to organize the 10th anniversary of the court here in Arusha, Tanzania. It is an opportunity for the officials to take stock of what has been done for the past 10 years and to chart the way forward. It is also an occasion for them to call on other states that have not ratified the protocol to do so in order that Africans should have the opportunity to see their rights protected. The 10th anniversary celebration took the form of a two-day symposium on the theme Celebrating a Decade of Human Rights Protection in Africa. Representatives of African Union organs, national human rights institutions, bar associations of AU member states, the academia and civil society organizations, among them ECOSOC, were present to make their voices heard on the achievements, lessons learned, and the way forward for the African Court.
As the court celebrates its 10th anniversary, which of course is a long road, much has been done, but I know much still has to be done. ECOSOC, which is one of the organs of the AU, just like the court, just like the African Commission on Human and People's Rights, is here to add its voice, especially as ECOSOC is that platform of the civil society in the continent on the protection of citizens' rights in the continent. I wish to say one of the coalitions which work directly with the court and which is a member of ECOSOC, the coalition of the court, has been at the forefront of advocating states to endorse the fact that civil society could also make declarations in the court. And this is something that has to be taken serious. Now we have 8 countries that have already endorsed this declaration. And we hope and wish that many other countries could also follow the footsteps of the 8 countries that have endorsed for civil society declarations in the court.
Delegates at the 2-day symposium that took place on the 21st and 22nd of November 2016 were treated to a wide range of themes, amongst them the historical genesis of the African court.
As we celebrate the 10th anniversary of the court, which celebrations are also part of the 2016 Year of Human Rights in Africa, my presentation was intended to inform about the journey we have taken to arrive at where we are today, 10 years later. What was the process? What was the journey like? Were there twists and turns, or was it just a straight journey? And in the process, I've also touched on the challenges that the court is now facing and what I see as the future of the court. Some of the challenges that the court has faced has been the fact that the process of ratification of the protocol has been very, very slow. Right now, out of 54 states, only 30 states have ratified the protocol. And in order for individuals and NGOs to access the court, you need a declaration to be filed by the states. And only 8 have filed the declaration, and one state, Rwanda, has withdrawn the declaration. The process of drafting the protocol was very complicated, as you would understand, starting in 1994. And every time a draft was brought to the Executive Council, to the Council of Ministers, they would then say, we need more comments from states, more comments and observation from the states. And therefore it was sent back about 4 times. And 3 government experts meetings were convened. And eventually, after the 3rd meeting, which had been enlarged to include ambassadors in Addis Ababa, the protocol was adopted by ministers of justice and finally by the Council of Ministers of the OAU and the Assembly of Heads of State and Government. It is one thing to ratify or accede to an instrument, but it's also another to implement it. So we are having challenges on 2 fronts. We have a challenge with the fact that some states have not ratified the protocol or filed the declaration. But we also have challenges with the fact that some states are yet to do either. And therefore, access to the court by individuals and non-governmental organizations is limited. And therefore, we would like to appeal to states that have neither ratified the protocol nor filed the declaration to do so that their nationals can have access to the court. But also, there's a lot that can be done at the national level, because the primary duty for implementation of the African Charter on Human Rights is the member states. It rests with the member states. It's not possible that the court can deal with all the cases that arise. And therefore, the national process is very, very important. And therefore, states ought to be able to make it possible for their citizens to seek redress at the national level, because the African court can only deal with cases where local remedies have been exhausted. If somebody comes to the court and they have not gone to the highest court in the land, the court will not deal with the matter. And therefore, the access is very limited, even where there is a declaration. And therefore, we like to appeal to states and also national human rights institutions, civil society actors at the national level, to strengthen their efforts in this regard. Because as Nelson Mandela said, if you deny people their human rights, you are challenging their very humanity.
The fact that only 30 countries out of the 54 that make up the African Union have ratified the protocol and only 8 that have deposited their declaration recognizing the competence of the African Court to receive complaints from individuals and NGOs is a big challenge to the Court and the African Union as a whole. If many more countries deposit their declarations and the Court having a proper enforcement mechanism of its judgment, then the culture of human rights protection may be respected in the continent.
The true value of a court of law, as I said previously on other occasions, it's not so much how many cases disposes of. Remember, the true value of a court of law lies in its deterrent nature. If we have got a court which can effectively, as it were, deter people from violating human rights, that is the true value of the court.
It's a birthday party. Everybody sing the song.
Lessons to be learned from the court after 10 years put forth by Justice Gerard Nuyongeko, a former president of the African Court from Burundi, says the court needs innovative solutions, that is, the court's self-promotion, the necessity for quality justice, the challenge of enforcing the court's decision, the slow implementation of complementarity between the court and the African Commission on Human and People's Rights, and the utility of external partner contribution such as the German International Cooperation GIZ, the European Union, the United Nations Office on Human Rights, amongst others, are some of the issues the delegates had to grapple with. Delegates at the symposium were also very critical about the jurisprudence of the court after 10 years.
The court has decided a couple of cases already that have implications beyond the specific cases. The case against Tanzania in relation to independent candidates, the case against Cote d'Ivoire recently in relation to the composition of the Electoral Commission. These are cases that have relevance beyond the specific countries. So how can the Commission take general principles, draw general principles out of these main cases and perhaps adopt a general comment or principles in a way that complements, that advances the broader impact of decisions of the African Court?
The delegate reflected on challenges of the court, such as the few number of state parties to the protocol, fewer numbers of declarations in accordance to Article 34, sub 6 of the protocol.
Creating awareness amongst member states to ratify the court's protocol and make the declaration allowing individual people from across Africa and NGOs as well to file applications at the court directly for those countries which haven't done that. Because so far we have a few of them which have done so. So, you know, applications against other countries that have not filed these applications are not possible to be heard by the court.
Other challenges such as the general lack of awareness, inadequate resources, and lack of a proper enforcement mechanism of court's judgment came out paramount during the discussions. Delegates at the symposium from time to time were given the opportunity to flex their muscles after serious debates to permit them exchange ideas on the different themes before moving back into the conference room. The 10th anniversary celebration of the court was a clarion call for the entire continent to look forward to a brighter future for Africa an Africa which truly mirrors the vision of the court, and an Africa with a viable human rights culture.
The court is operational, and the court is a judicial organ that the African citizens, that everybody, the community, international community, should trust, because we do our work in an independent way, impartial. So the message I want to send is that the court is created for the African people, is created for all the nations. Is not the court for the judges, is not the court for the states, but is the court to solve the problem of human rights in Africa. So the message we want to send is that we should protect the court. We should give all the support to that court, because it's a common heritage, is the common good for the African, for the citizen, for Africa.
Within a decade, according to the delegates, the court has brought about renewed hope and optimism within the human rights system, and positioned itself as a veritable instrument in the quest for regional integration, peace, unity, good governance, respect for human rights, and development. On the sideline of the symposium, officials of the court and partners granted a press briefing, followed by the signing of a financial agreement between the court and the European Union.
Three-year support, 2.5 million euro to the African Commission on Human and People's Rights, and 2 million euro to the African Court on Human and People's Rights to strengthen the capacity of these two institutions to enhance their work towards the promotion and protection of human rights on the continent. If I may add, the European Union has been a partner to human rights organs on the continent for a very long while. With respect to the court, since the establishment of the court in 2006, that partnership has been growing from strength to strength over the years. So this is just part of the continuous relationship between the EU and the African Union organs.
Agreement with the European Union and the African Court is towards help the court to put in place an electronic case management system, and this system will actually enable the management of files more efficiently, processing of applications faster, so that they can be resolved faster, and it will also help people who want to file their applications to do so from wherever they are across the continent. It will also help the judges to handle the files from wherever they are in the world, and generally just to speed up the processing of applications, so that at the end of the day justice is served faster. The system will also produce statistics on the applications that have been filed, nationalities of the applicants, their age, gender, what kind of cases they've filed, so that we can able to gather these statistics and inform the African public and African member states about the kind of work that the court is doing. Just general awareness raising about the court's work. Then the second aspect of the support is to support the legal aid scheme of the court, and by this we mean connecting indigent applicants or needy applicants to lawyers who already meet qualifications to appear before the court, so that they can be supported to proceed with their applications, so that at the end of the day they can be able to argue their case properly. And then, you know, because sometimes you find that the states usually have the state council, they have the lawyers at their disposal, whereas the applicant is at a disadvantage. So that is why the scheme has been put in place for those deserving cases to be given that assistance. Then the third aspect of the support is towards creating awareness amongst member states to ratify the court's protocol and make the declaration allowing individual people from across Africa and NGOs as well to file applications at the court directly for those countries which haven't done that. Because so far we have a few of them which have done so. So, you know, applications against other countries that have not filed these applications are not possible to be heard by the court.
Cultural evening was organized to crown the anniversary celebration, during which the anniversary cake was presented to the public. Other activities were organized during the evening that kept everyone spellbound.